Good morning, everyone. Thank you for joining us today for this workshop on copyright issues in secondary data use. My name is Hina, and I work as a senior research data officer within the research data management team, and I'm based in University of Essex. This session includes of course, presentation, and you will, as I mentioned, that you will get the slides after the session. And I will also be using Mentimeter throughout the session, which can be accessed on this link. Using the code, you can scan this QR code from the camera of your mobile. You can keep it open because I think I will use it twice during the workshop. And as I mentioned, I have prepared some case studies as well on the Padlet, which can be accessed using this QR code, but Gail will enter the link to the Padlet when we need it, hopefully by the end of the session. So in this session, I'll focus on intellectual property rights, specifically copyright in the context of research. I will begin by explaining briefly what secondary data is, which is then followed by discussing what rights might there be in research. I'll also discuss some issues that are very important in this context, such as licensing your data when you intend to share it for future use, establishing right ownership, challenges in sharing social media data, and national variation in copyright. I'll also discuss some best practice tips to ensure rights compliance when it comes to sharing your data for future use. And finally, I'll point you to the resources that may be useful for you. And I'll answer your questions at the end. If there are any specific project related questions, you can always email us and I'll be happy to answer those. And I will provide, I think I have added my email address on the last slide. So IP rights are the rights that are granted to creators of works that are result of human intellectual creativity, something that is created using your mind. For example, any story, any invention, an artistic work, or a symbol. So types of IP rights includes trademarks, which is a type of IP consisting of a recognizable sign, design, or expression which identifies products or services of a particular source uh, from those of others. While patent is another type of IP right, it is an exclusive right granted for an invention, while third type of IP right is registered designs, where that protects only the shape or appearance of a product. It gives its owner the exclusive right to the design of that product. And the final type is copyright, which is the protection offered for creative works such as books, music, literary work. And you get some type of protection automatically, but for some types, you need to apply for that. And we will be focusing on copyright today. So I'm sure you know what secondary data is, but there might be some people who have no idea. So let's begin with what secondary data is. Unlike primary data, which is collected by a researcher directly from the original source, secondary data is an existing data gathered from studies, surveys, experiments that have been run by other people or for other research. And for example, existing data available at archives or from government organizations, essays, reviews, information available on social media, and so on. So this is called secondary data. So a quick question, have you used secondary data or you are planning to use it? You can just answer in a chat box if you would like to. If anyone of you have used secondary data or you are planning to use secondary data. All right, thank you. So you are planning to use So that's great. I hope that today's session would be helpful for you as you are in the planning stage. So that is great. So someone has already done it. That's good. Most of you, apart from one, you are planning to done it. So that is great, and I hope that today's session will be helpful for you. Thank you for your responses. So, excuse me. Two most relevant types of rights applicable to the secondary data sources are copyright and database rights. I'll be focusing on copyright in today's session, and I have given a link at the bottom of the slide for the information related to database rights for you to have a look at later on, because it's beyond the scope of today's workshop to cover both of these. So, copyright is, as I said earlier, copyright is an intellectual property right assigned automatically to the work's creator. And it prevents unauthorized copying and publishing of an original work. And the creator is automatically the first copyright owner, unless there is a contract that assigns copyright differently, or there is a written transfer of copyright signed by the copyright owner. And it can vary nationally. But under the UK Copyright Designs and Patent Act 1988, copyright applies to original literary, dramatic, musical, or artistic works, sound recordings, films, broadcasts, or cable programs, the typographical arrangement of publications, and even the databases as well. In the UK, copyright arises automatically once a work is created. To enjoy copyright protection, the work must be original. That is to say, it must be your own work, not copied from someone else, and there is no copyright in ideas or facts, only in the way those ideas are expressed, such as diagrams, tables, and so on. So, as researchers, when you need to obtain copyright clearance, for this, you need to bear in mind that you do not need copyright clearance if you incorporate the factual data in your own words in a structure owned by yourself. You may not need to obtain permission if you are making a copy and utilizing that copy for your own research, as long as it is not made available to others or citing from the research data. However, you do need copyright clearance if you are going to include the secondary data in a publication or plan to share that data with other people. It also applies to incorporating secondary data in your own database that you intend to share with others. It will be more clearer to you when I will discuss some case studies by the end of this session. There may be some other arising issues, for example, where personal data is concerned, not only the permission from the person who has created the work is required, who is the copyright holder, but permission from all the people whose personal data is in the work is required. And an example is the diary data. So, copyright and research data is a complicated topic. However, I have tried to highlight some important issues when it comes to data sharing. Researchers need to keep in mind certain considerations such as licensing frameworks, rights ownership challenges when using social media data, and the national variation. So, in the following section, I'll go through each of these. IP rights affect the way both you and others can use your work and others' research data, and these issues should be considered at the outset of any research project. So you need to consider copyright when the data is created, shared, and reused. For example, when you create a data and plan to make it available for future use, then no doubt you are the copyright owner of the data. But there is another issue you need to consider, which is how you want your data to be made available And here the role of licensing comes in. If you are sharing your primary data, then you need to consider about which license to choose. On the other hand, if you are using secondary data, you need to pay attention to the licenses under which that data is available. So the data collections can be available broadly under two types of licenses: open licenses and bespoke licenses. And as the name implies, open license is a standardized way to grant people permission to use the data openly. For example, the most widely used open license framework is the Creative Commons license framework. And Creative Commons license framework offers different options. Three of these have been listed here. The first one, which is CC BY, is the most widely used license. And as you can see that you are allowed to use and share the data. You can create some derivation with it, adapt it as you require, publish your derived data as long as you acknowledge the original data source. And it also allows commercial use, for example, for non-academic purposes. The only condition is that the credit must be given to the creator. For example, you have downloaded a data set which is available under CC BY. You are allowed to use it for your own analysis. You can create your own data set using few variables from the original data, and you are allowed to share your data for future use by giving proper attribution to the original source, and you can make your data available under any other license that seems appropriate. The second one is CC BY share alike, and it is exactly similar to the CC BY apart from one condition, that any adaptations must be shared under the same license. Your data should be made available as CC BY share alike. The final one is the CC BY non-commercial, which has again the similar conditions except that it cannot be used commercially. So you need to consider it carefully under what type of licenses to use and what type of licenses are attached with the secondary data you are using. So most of the data made available through responsible repositories such as ours, you get UKDS, is made available under bespoke licenses, as there may be a residual risk of disclosure in data. For example, data owner might have removed any identifiable information, but there may be any information left in the data which, if combined with other information, may disclose someone's identity. So the conditions associated to these bespoke licenses ensures that researchers act responsibly and ethically with the data. UK Data Service End User License Agreement is one of the examples of the bespoke licenses. So if you are planning to use secondary data, always make sure that you are familiar with the terms and conditions under which the data is made available. That's very important. So just a quick glimpse. Here at UK Data Service, we facilitate three levels of access for data: open access, safeguarded access, and controlled access. If you are using our data sets, then you come across these three levels of access, or you are planning to share your data or deposit your data with us, you are being offered these three levels. So open access is for the data that contain no personal information, or if there is some personal information, but the consent to share that personal information is in place, then we put that data under open access. Then safeguarded access for data that contain no personal information, but the data owner considers a risk of disclosure resulting from linkage to other data or combining some pieces of information in the data. It is available under end user license, and users need to register to access data. Users also need to agree to certain conditions, such as not to disclose any identifying information. Controlled access, on the other hand, is for the data that may be disclosive. Control data are only available to users who have been trained and accredited, and their data usage has been approved by the relevant data access committee. And access is through a virtual or physical secure environment. So then there is a very quick activity on the Mentimeter. Who owns the right? If you could please, I'm just trying to share. Um, if you could just join the Mentimeter by following this link and entering the code, or you can just use the Mentimeter using this QR code from the camera of your mobile. It's just a small activity. Just waiting just for a minute so that you can join it. So yeah, you can either use the QR code from the camera of your mobile, or you can just go to menti.com and enter this code to join us. Okay. So let's see which options you would pick. So what do you think? Who owns the right when um, any employee or staff is doing a research in the university? Is it the university who is the right copyright owner? Is it the employee, or it depends? What do you think? I'll discuss the answers after finishing this activity later on. So I'm just asking about your opinion. So some of you said that it's university, majority of you said it depends. And yeah, that is right. Both choices I think are right. It depends. And when it comes to students, what do you think? Who owns the right? Yeah. So there are no right or wrong answers. So yeah, I think it depends on the context, and I'll go through the detail in a moment. Yeah. So it could be a university, it could be student, it could be, it depends. Thank you. And who owns the right when it comes to the funded research? Is it researcher, research funder, or again, it depends? Yeah. So it's equally either researcher or it depends, or someone thinks that it could be a research funder. That's right. Thank you. And I think that's the last one. What do you think? Who owns the right in a collaborative project? That's, I think, an open-ended one. Sorry. Equal decision, it depends. Everything is it depends. That is right, I think. The best answer. Yeah, it depends. Yeah, exactly. It depends on the agreement between partners. Yeah, depends on agreement between collaborators. Shared responsibility, shared copyright. Yeah, it could be a joint copyright ownership. Equal rights, yeah. As a matter of rule, I think equal rights, but it depends on the agreement, what has been decided between them. Thank you very much. Let's go back. Yeah. So, thank you for your responses. I think someone has, most of you have written that it depends. For every, I think, question, it depends is the best answer. But you just need to bear in mind that rules on IP ownership will also depend on national law and institutional policies as well. And they may vary from country to country. So that is important to keep in mind. However, as a general rule, the copyright in a work is initially owned by the work's creator, but as you said, that it depends. If a work is created by an employee in the course of his or her employment, the employer owns the copyright unless otherwise agreed upon differently. Many universities or research centers claim ownership of any IP that is generated by academic staff in the course of their employment, and also when IP is created using substantial institutional resources. And when two or more authors prepare a work, then the intent to combine their contribution, the authors are considered joint copyright owners. And in terms of the students, most universities do recognize as a general principle that students who are not employees of the university own the IP rights in the works they produce, purely based on their knowledge received from lectures and teachings. However, there may be some circumstances where ownership has to be shared or assigned to the university or a third party. And typically, these include sponsored students, students working on research, thesis, or publication in collaboration with academic staff. So, yeah, usually sponsored students may claim copyright ownership, and unless it is agreed otherwise. And research funder may also wish to exert some claim over rights, although in most cases, IP rights are attributed to the researcher unless an output becomes commercially viable. And if a university research project has commercial collaborators, there may be joint IP rights in the research outputs, which are best handled via legal contracts or agreements. And it is important that researchers should clarify ownership and rights relating to research data sources for both primary and secondary data being used before embarking upon research. And this in turn will help determine how those data can be published and accessed in the future. But best practice is to find out the ownership as soon as possible. And just um, take home messages, it depends how it has been agreed on the, it always depends on the contractual agreements. So it is not that hard to find out who owns the right if you are affiliated to any university or research center. There should be a staff in there who deal with the ethical and legal compliance in research, like REOs, or you can find it looking at the applicable national IP law, IP policies of your institution, and the individual contractual agreements among the university's creators, sponsors, or you could seek a legal advice as a last resort. Because failure to do so can cause serious issues for the future uses of your research data, such as its dissemination and any future related research projects or profits associated with it. And this is applicable especially in the context if you are planning to share your data for future use in any repository. So the next issue to consider is the copyright consideration when using social media data. I'm sure you are very well aware what social media is. It is an umbrella term used for internet-based or mobile applications that allow users to form online social networks. And some of the very popular ones are Facebook, X, Instagram, Snapchat, LinkedIn. However, the most widely used among these in the context of research is X. which used to be called as Twitter previously. So the data is usually obtained through the application programming interface, APIs of the social media platforms. APIs are provided by social media platforms to enable controlled access to their underlying functions and data. And API act as an interface between the social media platform and a consumer of social media data. For example, the X streaming API allows researchers and collecting institutions to obtain uh, posts or tweets generated by users in real time, thus accessing data through API provide the most authentic record of social media. And the data available on these platforms include individual posts or tweets, what people share on a day-to-day basis, and how people comment on posts, show their opinion, behavior, likes, dislikes, visual content such as photos and videos, interests, social interactions, and so on. Everything is there. Um, these different platforms poses a wide variety of functions and appeal to different audiences, and they all create a byproduct of valuable data about the users who interact with them. So yeah, just a couple of questions on social media data. If you would like to just reopen Mentimeter using the same code or QR code, please. Just a couple of questions. So that's the code and or the QR code. That's the last activity on the Mentimeter. So just a quick question. Have you ever been involved in a research that involves social media data? So majority of you know, not, and one of you is involved. So that's good. So a couple of you have been involved, so you must be aware of the challenges associated with using social media data. Thank you. And what do you think could be the copyright issues using social media data? Any thoughts on that? Even if you have not used it, any issues that you can think of? What could be the copyright issues? Use of audio or music background. Personal data exposure, yeah. Yeah, it's about the copyright issues. So yeah, do you have permission? That's right. Sentiment analysis doesn't always tell you which user's data has been used. Okay. I'm not familiar with the sentiment analysis, but that must be a valid issue. Privacy, not sharing the truth. Yeah. So these are the general issues. I'm asking about the copyright issues, ownership issues. So the terms and conditions of the platform, that is right. And the question that do you have permission from the owner, that is a valid one as well. Any other thoughts before we go back? Yeah, even though every opinion is public, I think the copyright belongs to the other person. That is true. Copyright transfer between poster, platform, user agreement, researcher, API agreements. Yes, that all depends on the agreement, terms and conditions, permissions that are in place using those APIs and social media platforms. That is right. Thank you very much for your responses. Let's get back. Yeah, so you are very right. The terms of use for the most commonly used social media platforms are similar in terms of how they deal with IP rights. Content is protected by copyright in the same way as books and journals. Whatever you post on these platforms is considered your creation, your content. So these platforms clearly states that the users have copyright for their own content, and users are the copyright holder of their content. So though you are the copyright holder, but when you agree to the terms and conditions to create your account on these platforms, you sign an agreement that gives the site a license to freely use the work for a variety of purposes, including an opportunity for researchers to access the data for academic research. So, researchers using social media data need to abide by the terms and conditions of the platforms or these API developers. So, the terms and conditions of these social media platforms or API developers play an important role in terms of the future uses of data, such as publishing or archiving it. I will be using X or Twitter as an example, as it is the most widely used social media platform across the world, and it is relatively easy for researchers to collect data from it. Um, as an open platform, the majority of the posts are available to public view, and researchers can collect large number of tweets or posts in a very short period of time via the platform's API. However, it is a valuable source for research, but researchers do face challenges when it comes to publishing data or archiving it for future use. For example, after a researcher or research team has created a data set, it is not usually possible for them to deposit that data with an archive or collecting institution for reuse. This is because if we take an example of the X or Twitter policy restricts from sharing any data. Um, they obtain from the API and also from storing data in a cloud. The policy does, however, allow the archiving of just the post or tweet IDs, the unique number given to an individual tweet or user ID, the number assigned to Twitter account holders. They can share that number, but not the original post. And other researchers could use that ID to create a data used in a previous study, but only if that platform continues to provide access to historical data. It is not ideal, but at least it provides a better solution than sharing no information at all about data sources or published studies. Uh, there may be another challenge. For example, researchers use different methods to access social media data from different APIs, different tools, different platforms, different resellers with different services, which create very diverse types of data sets. So, individual researchers may use different methods to clean or organize their data, as well as different tools or methods for analyzing that data. So, in addition to the IDs associated with the data set, information about how the raw data was collected and how it was cleaned is also important and will be required for recreating a data set or understanding how and why it has been altered. Therefore, the archiving of the data set identifier is more effective if the processes used to create them are also documented. In the context of X or Twitter places, but particular restrictions on the form in which posts or tweets may be published, requiring certain items of data to be retained in the published form. The forced retention of this material may pose a challenge to privacy. For example, if you need to quote some tweets while publishing, you cannot anonymize the tweets as the platform does not allow modification in the content. You need to use the full post as it is. So these are some of the challenges, but these most of the platforms do allow to use the post IDs, and any future researchers could create their own data set by using those IDs. And as I said, it's not ideal, but better not to share uh, the data at all. So Here I have added a useful checklist by UCL, though it is for the reviewers, but can be useful for the researchers who wish to use social media data. So you can go through these questions and address any concerns beforehand. So another important point to keep in mind is the copyright in the international context, and the following section is about this. Just a quick question. If you would like, you can just add it in the chat. In which country you are carrying out your research? Is it the UK or outside the UK? If you would, oh, Colombia, Germany, UK, that's great. So most of you in the UK and someone in Colombia and Germany. UK and Bahrain. That's interesting. Maybe you are doing a comparative research, as I did in my PhD. Yeah, yes, yeah, I assumed that. I have compared the health perception management and prevention between the South Asians living in the UK and in their home country. So that was my health in the context of health psychology. So that's interesting. Thank you very much. So coming back to the topic, every country has its own copyright laws, and if you are doing the research outside, for example, EU is most, Germany would be, I think, similar to the UK, but Colombia and Bahrain, they may have their own copyright laws. But over the years, there has been extensive global harmonization of copyright laws through treaties and trade agreements. And excuse me, these treaties and agreements established minimum standards for all participating countries. This system leaves room for local variation as well. And one of the most significant international agreement is the Berne Convention. I don't know how to pronounce that, so apologies for that. Though it was signed originally in 1886, but it has since been revised and amended on several occasions. And this treaty lays out several fundamental principles um, upon which all participating countries have agreed. And one of those principles is national treatment, which means that all countries must give foreign works the same protection they give to the works created within their borders, assuming the other country is a signatory. And most of the countries are signatory, I think, apart from just few. Besides this, the minimum standards also include the type of work, protected duration, limitation, exceptions, and so on. So the national laws are built on the similar basic standards, but there may be variation on a country level in terms of type of work, duration, and exception. I'll give you an example. Sorry. This is an interesting map which gives you an idea of differences in copyright duration around the world. We can have a look at the map from a, if you go back, then according to that convention, the minimum term is set as life plus 50 years in terms of duration. So if we look at the map from a continental perspective, we can clearly see patterns of same duration with small exceptions. I'll just let you look at it for a few seconds. You can see that in Europe, America, Canada, most countries adhere to life plus 70 years. And in comparison, in Africa, we can see the continent is dominated by life plus 50 years with few exceptions. And Mexico stands out and is actually the only country to adopt life plus 100 years. So, all the signatories of that convention, they abide by the standard duration with the national variation. And they could go plus 50, plus 60, 70, 80, 90, 100. So, but they must be abiding by the minimum standards. So, in terms of the copyright ownership, if you are working across countries, you should be aware of the national variations as well. So that's an important issue. So if you plan to use secondary data, always ensure that you consider these questions: who the copyright holder of the data set is, can you use these data sets, and in what way? Are you allowed to archive and publish them in a data repository, which is very important because if not, you may need to seek further permission to distribute material you do not own, because if permission is not granted, you may need to remove copyrighted variables or material before publishing or sharing. Um, um, uh, Here, I should mention that copyright law does allow certain exceptions. For example, you are allowed to copy limited extracts of works when the use is non-commercial research or private study. However, in the context of data sharing, researchers are not allowed to share the secondary data unless they are allowed to do so. The majority of uses of copyright materials continue to require permission from copyright owners. So you should be careful when considering whether you can rely on an exception, and if in doubt, you should seek advice on that. And finally, do remember that the details of the provisions will be subject to the national law, and while most will be similar, details will vary from country to country. For example, users of copyright work based in the UK are subject to the specific exceptions to copyright outlined in the UK copyright laws, since each country will have its own exceptions to copyright, which are likely to vary from one country to another. Users in one country will be able to reproduce copyright work under the copyright exception in ways that users in other countries will not. So always check your national law if your research is spanning across countries. Here I have added a scenario. For example, imagine a researcher has used secondary data sources for a research project, and he intends to share this data for future use. It's a real case study or scenario because we do get research data from a depositor who has used these two sources to get his data, and he wanted to deposit this data with us so that the data can be used by future researchers. So the sources he has used were World Bank and Microsoft Academics to obtain that data. And as he has used secondary sources, he should have checked whether he is allowed to share the data he has used from these sources. And how he can check? He needs to check the terms of use, and which are usually mentioned on the website of each resources. You need to, it's hard, sometimes it is hard to find, but the information is there. If it is not there, then anyone can write to the source and they can let them know. So I have put the terms and condition of use here from the World Bank on the next slide. For example, this is a screenshot from the World Bank. Here you can see that it is mentioned that there is no restriction on sharing the data with the third parties. So that the data obtained from the World Bank is okay to share with any repository. However, terms of using Microsoft Academics, they have mentioned that you cannot modify, distribute, publish the material you obtained from them. And if you want to do so, you may need to obtain permission. So this is an example. So always check this if you plan to deposit your data for future use and you have used secondary data sources. So that was an example. Here on this slide, I have added links to our web pages on copyright and access levels. I have also added a useful template here, which is variable information log for which is useful for secondary data users. And researchers are advised to prepare this log describing the sources. This not only allows others to understand and use data correctly, but also ensures that repositories can check the appropriate terms and conditions applicable to onward sharing. And yeah, following two slides also have links to more resources that could be useful for you. So I think that's it. And now let's get to the case studies. I think Gail will add a link in the chat for you to access, or you can just scan this QR code. No, I don't think so. I think that's the previous QR code. There should be another one. So I'm sorry about that. There is a new QR code on the top left bottom of the screen. You can scan it from here. Oh, yeah, thank you, Gail. Gail has added the link to access the Padlet. So I have added 5 case studies here. I'll give you 10 minutes maybe, and then 10 minutes or 15 minutes, I'll see. And then we can discuss each of these. So it's anonymous. Just feel free to write whatever you think would be the right issue in each context. And we will discuss it at 10 past 11. Meanwhile, if you have any questions, feel free to add it in the Q&A box and I'll go through these while you are writing about the right issues for each scenario. I'm sorry, I thought it's anonymous, but it's not. Apologies for that. So in terms of there is a question, comment on the first case study. Someone has not understand the question. So this is for in the context that if you imagine a research project where a researcher is collecting diaries. It's a qualitative research where some researchers collect diaries from different people, what they write on a day-to-day basis, and they just do some research or they try to answer a specific research question. And then they wanted to share the extracts from those diaries, either in a publication or they wanted to share those extracts or that qualitative data in a repository, for example, with us. But sometimes it happens that the owners of those diaries, the participants, they also wanted to publish their diaries in future. So what could be the copyright issues in that case? So you need to think about that. Who would be the copyright owner? How to resolve the copyright issues? So this was the question. It's 10 past 11, so thank you very much. Great responses. I think you just understand It's the term and conditions, the agreement that has been decided, the consent. These are the things that matters in the context of copyright. So thank you very much. Great answers. I think you get the point, or you already know that. So thank you very much. So the first scenario was copyright in a project based on diary data. So all the responses or the discussion that you have through, I have read all the comments. So that's each of the comment, you are right. You can use the information obtained in the discussions or the information you obtain from the diaries for your own research. However, when it comes to data sharing or publishing, you do need to obtain permission from the participants to share their personal information. So you need to obtain consent, as some of you have mentioned, to share that information and permission to use the data for future use, future research. And as some of you have mentioned, that setting up an agreement with each diary participant would be a great idea, and it would be a less hassle later on. And in terms of the ownership, yes, everything should need to be decided upfront before the project begins. So exactly three things, I think: consent, permission, everything that needs to be agreed upon should be uh, um, decided before the project begins. So thank you very much for all the comments and answers. And in terms of the second one, copyright of the information available online, exactly all the information or the comments or thoughts you have shared, they are correct. Even though the articles obtained are freely available online, they might still be subject to copyright. And as one of you have mentioned that in your experience, um, each and every source would need to be checked. That is exactly what needs to be done. Yeah. So you can use the information for your personal research purposes, but the articles cannot be archived unless permission is obtained from the sources. And terms and conditions of all the sources used needs to be checked before the archiving process begins. That's why I have added that variable information log onto one slide where you can just list all the sources and information about the terms and conditions. So all the answers, they're right, well done. In terms of the the third case study, copyright of archive data. So yeah, although the ISSP data are available for free to all registered researchers, this does not mean that the data can be published on a website and made available to others. The data can be incorporated into a database and used for personal analysis, but before this data set is placed on a website, permission must be sought from the data owner. So all the comments, uh, they are very right. Yeah, no, they do need permission. And in terms of the fourth one, transcription from a printed work into a spreadsheet. Here, the researcher should technically have cleared copyright before transcription, and if the work is for personal use only, this can probably be disregarded. But if the newly constructed dataset is to be archived and disseminated, copyright clearance will need to be gained from the copyright holder. There was a comment here about the duration. Somebody has written, what if the book is quite old? For example, life plus 50 years and data is cross-checked, validated, and corrected. I think if the copyright duration has passed, then it is considered to be in the public domain. So then that is not a problem if the copyright duration has passed, which is lifetime plus 50 years or whatever the copyright duration is. So again, checking the terms and condition is an absolute must. And the fifth scenario was about the copyright I'm sorry, I can't read it because, yeah, now I can. Copyright of open data obtained from us, from the UK Data Service. So, yeah, here again, you would need to point to the original source. And if it is open data, I think you just need to check the terms and conditions. If it is available and under Creative Commons share alike, then you need to use the same license. If it is under Creative Commons CC BY only, then you can, if you remember the slide I have shown you, you can just do whatever you want with the data. You can modify it, you can make derivative work from that, and you can use your own license. But if it is under CC BY share alike, then the only condition would be to use the same license as the original data source. Yeah. So it depends on the licenses attached to it. Because for the open data available from us, usually we have Creative Commons licenses, and the type of Creative Commons license that is used for that specific data set will uh, tell you what you need to do with the with that particular data set. So it's all about, I think the take home message would be just to check the terms and conditions. You can use any source, any data for your own personal use, but if you are uh, about to share it for future use, then I think it's best always check the terms and conditions, the sources, the licenses attached to it. Um, that would save you time. So that's it. Thank you very much for the responses. Very knowledgeable audience. Attendees today, I would say, looking at the responses and the discussion and the comments on the Padlet. So thank you very much. And if you, I have answered the questions while you were writing. If you have any other questions, feel free to write it. And I will write my email address. If you have any specific project related questions, you feel free to add it. Email me, sorry. Is there any questions? I hope you get some information from today's session. I'll be running a general ethical and legal considerations that you need to consider when you plan to share your data. I think it's next Thursday, same time. And then I will be running another workshop on consent issues. My colleagues, I think they are running different uh, workshops related to research data management. So you can scan this QR code to register for our future training events. Here, the second one. And yeah. There's a question, what if you take information from a publicly available source, such as company ownership information published at Companies House? Yeah, you can take it. You can create an Excel sheet, a database, take several companies' names, company information, ownership information, assets, and whatever you want to take, create the data set for your own personal research purpose. But if you think that you need to deposit that data set with any repository, only then you need to check the terms and conditions associated with the Companies House, whether they allow you to share the information with third parties, with research repositories or not. So then at that point, it's not the case that the people are not allowed to use the information publicly available, you can use it. You can publish a research paper based on that information, but in order to disseminate, in order to publish, in order to archive that particular list or data set or variables taken from company's house, you need to check the terms and conditions uh, before sharing it with the third party. I hope it's helpful. Yeah, there is another question. What if a journal requests replication data, but a text corpus cannot be made publicly available? Then you need to speak to the journal, letting them know that it can't be made publicly available. That's a discussion point of view that should be, I think, considered before starting your research, because most of the journals these days they are asking for the data to be deposited as well. Most of the research funders, they are asking these days to deposit the funded data for future research. So that's why I think these workshops are helpful for you to consider before you start the research project. Before the onset of any research project, you just need to consider these aspects. What you are going to say to the journal, you can start discussions, you can let them know that it is not possible, or you could obtain consent from uh, the people whose data is involved. So these are some of the considerations that should be considered before the onset of research. But if you are in the later stage, then the only thing I would say is to discuss this with journal, that why it is not possible to share this data. Maybe you do not have the consent in place. So yeah, this is just a discussion point of view, I think. Is there any other question? If if there isn't any other question, then thank you very much for attending today's session. And thank you very much for keeping the Padlet busy. This is for the first time that I have received so many answers and comments, and which is really great. Thank you. So this is my email address. There is a shared email address as well. And yeah, feel free to write to me if you have any question later